Most of us learn about the president and Congress. But what about our judicial branch, especially the Supreme Court of the United States? Article 3 of the U.S. Constitution says, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." Congress established the Supreme Court back in 1789. The Supreme Court has power equal to Congress and the President, thanks to Chief Justice John Marshall, who created judicial review. The Supreme Court has the duty to determine whether the other two branches are following the Constitution. The U.S. Supreme Court has one Chief Justice and 8 Associate Justices. The Chief Justice is the leader of the court and decides who will write the decision and how the court runs. Our Constitution doesn't exactly say how many justices should be on the court. At first, there were only 5. There have been as many as 10. We've had 9 justices since 1869. Some attempts to add more justices or pack the court have basically failed. To get a job on the highest court, a person must be nominated by the president. They do not have to be a natural-born citizen. And unlike the president, who must be 35 years old to hold office, the Constitution does not require any minimum age to be a Supreme Court justice. Joseph Story was only 32 when he became a justice. The Constitution doesn't even say the person must be a lawyer. But it would be pretty difficult to get the job without legal training, since a Supreme Court justice must decide cases from every state as well as the federal courts and understand all legal issues. Once nominated by the president, the Constitution requires the Senate to give its advice and consent. Senators hold a hearing, something like a high-level job interview, and ask lots and lots and lots of questions. It can be intense. But once confirmed by the Senate, our new justice has a lifetime job. Justices can be impeached, but never fired. That's the purpose of lifetime appointments: judicial freedom. Just how does a case make it all the way to the Supreme Court? Well, it's a long road. Federal cases start with a trial in district court, with a judge and a jury. The loser at the district court can appeal up to the next level, called the United States Circuit Court of Appeals. At this level, a panel of judges hear their legal issue, not the entire case, and there's no jury. After the Circuit Court of Appeals, the losing party can appeal to the United States Supreme Court. States have their own trial, appellate, and high courts. State courts can only make decisions for their specific state. However, a decision made in a state's high court can then be appealed to the United States Supreme Court. Whether it is from federal or state court, the appealing party or petitioner must file a writ of certiorari, asking the Supreme Court to review their case. Justices then vote in secret whether or not to take a case. At least 4 of the 9 justices must be in agreement. With more courts, lawyers, and judges than any other nation, there are a lot of requests, over 10,000 each year. The Supreme Court only grants about 200 of those 10,000 appeals. That's a whole lot of disappointed people. From October until April, the court hears oral arguments. That means 2 sides stand before those 9 justices and argue their case. The justices ask questions, and attorneys must think fast. Any decision the court makes will impact more than just the parties involved. It will be the law of the land. The Supreme Court interprets the Constitution and follows precedent, not president, Precedent. Precedent is the established case law based on previous Supreme Court decisions. Judges look at those prior cases to see if similar legal issues have been decided before. That doesn't mean precedent is always followed. The court's interpretation of the Constitution can change over time, especially as new judges change the composition of the court with their ideas. So sometimes the Supreme Court will overturn or reverse a prior decision. For example, in Plessy v. Ferguson, the court found that racial segregation was legal. And then, years later, in 1954, they ruled that segregation was unconstitutional in the case of Brown v. Board of Education. The Supreme Court has the power to overturn decisions by lower courts and find federal laws to be unconstitutional. However, Congress can pass a new law clarifying the overturned law in order to make it constitutional. In the end, it only takes 5 of the 9 justices to make a decision that can change the entire country. Whatever they decide, we must follow, even if we don't want to. Let's review. The Supreme Court of the United States falls under Article 3, the judicial branch. There are 9 justices. The court ensures the President and Congress follow the Constitution. It can make rulings on state cases and federal cases. Once a case is decided, that creates the law of the land for all of us. This is your democracy. Keep it strong.